Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions today, one from Anonymous on Facebook and one from an agent as well. And then we're going to go into the first question with yourself, Nick, which comes from Anonymous on Facebook. Anonymous says that she signed or he signed an agreement to purchase at the beginning of this year. She also paid the deposit, and the property is supposedly ready for occupation this December. Due to some financial difficulty for family member losing their job, she needed to then become the financial bearer of certain responsibilities, and now won't be able to afford that property any longer. She did consult an investment consultant, which advised her to sort of go via email that she could cancel at any time and get that deposit that she paid refunded, right? So her question is, would that type of cancellation via email actually carry any weight, and can she even cancel, and what of course be the implications of such, and what are we looking at in terms of wasted costs in our opinion? Nick?
Okay, so obviously the trick with this particular question is there's obviously an offer to purchase and a sale agreement in respect of the property, and that's going to be the pinnacle document here. You've got to read that document. So this writer's already gone to see an investment consultant. I'm really hoping that the investment consultant consulted the documentation in question, because I mean, what their advice here, I'm assuming is going to be based on the particular document. It may well be correct. If there's an interesting OTP in the circumstances that just lets you cancel at any point without penalty. But from my experience, I don't think there's such a document. Okay, it's very unlikely to have a deed of sale in respect of an immovable property that doesn't have some sort of penalty if you're going to cancel the agreement. And in particular, the occupation is going to be given in December, which means this is already a long way down the road at this point. It's not like this contract was entered into yesterday. And they said that they contracted at the beginning of the year. So, it's very difficult for me to say without having had a look at the documentation, can I cancel? There might be something in the particular document that does allow you, but I feel that's very unlikely. And the more unlikely thing is getting away with cancellation without a penalty. Deeds of sale usually have what's called a rookkoop clause. Okay, now rookkoop basically says that anything that's paid prior to a cancellation of the agreement is going to be retained by the seller of the property as a pre-estimation of damages. This is a very common clause in deeds of sale, and it's an enforceable clause as well. So this writer has said already that they paid a deposit in respect to the particular premises. So obviously that deposit can be anything. It just depends on the agreement that's entered into. It could be 10%, could be 99%. And if that contract contains a rookkoop clause, it's very likely that whatever that deposit that's been paid in respect of the sale is going to be retained by the seller in the circumstances as a pre-estimate of damages. I don't know too many deeds of sale that don't have a clause like that, unless they are, a very special home written up sort of OTP. So in the circumstances, I know you've gone to an investor and they've provided you with advice on this. I don't know what the qualification of your particular investor is, but my suggestion would be go see a lawyer about it, just in case. Perhaps, maybe they're absolutely correct. The investor, the financial advisor you saw, maybe they're 100% correct. You go give it to an attorney and they go, yes, that's 100%. But just in case, that advice, the advice is just a little bit arbitrary from a legal perspective, I think. So just in case, cover your bases, make sure you go see an attorney, give them the legal documentation. Obviously, investors do a lot of different things, and they come from a lot of different angles for what they're trying to do for you. And sometimes they're not good at legal advisors. They aren't experts in interpreting contracts and dealing with the legal implications of canceling contracts. So I'd really say, do a double check, go see an attorney, seek out one of our officers, please. Let us have a look at the document. If it's a simple, straightforward thing, I'll speak for Bruno on this particular aspect. It's not going to be something that's going to incur a charge. It'll be a quick rinse over a document. If it's something more complicated, then at least you've done the groundwork and you don't get yourself into trouble.
Absolutely. Absolutely. So thank you very much, Nick, with regards to that. And once again, with OTPs, it's best to get them reviewed. So do reach out to one of our team members at BSA or SSLR. Let's get the OTP reviewed for you. Go on our website, take a look at the different products that we have, where we're able to take a look and go through different clauses of your OTPs. So thank you very much, Nick, for that specific question or answer.